Next presenter is a legend here at Gun Rights Policy Conference. You've seen him. If you're a veteran here, you know who he is. Don Kilmer, litigation counsel for the Second Amendment Foundation from the law offices of Donald Kilmer. And the topic for Don today is lower courts defying the Supreme Court, reason for caution or proof of victory. Don Kilmer.
All right, knock it off, everyone. This is a little difficult for me because I often get accused by judges of wandering around the courtroom and instead of standing at a podium, I'm going to have to do it now because I'm in front of a camera and I've got a microphone and these lights are a little bright, so bear with me. So when I was approached about a topic for this year's conference, I assigned myself this subject for somewhat selfish reasons. I wanted to confront an issue that has troubled me ever since I began my career as a Second Amendment litigator, and I wanted to do it in the presence of people who share my values and goals on the Second Amendment. The topic, are we winning or losing, and what is the evidence, can be sort of restated as follows. If the adjudication of the Second Amendment is so clear to me and you and my other circle of friends, why is it so opaque to others? And here I'm not talking about the advocacy groups like Bloomberg and Mothers Against Drunk Shooting or something. I'm talking about judges and government lawyers, okay, people who are trained in the law. And I don't think that partisanship is the entire answer here. Now, trust me when I tell you that Heller, McDonald, and Bruen are not just well-researched appellate decisions backed by history and text. They're also models of clarity. And this is not the case with all judicial opinions. Trust me, when I teach constitutional law to my students, I sympathize with them sometimes when we are slugging through some opaque Supreme Court opinions on dormant commerce or the 11th Amendment or rules for standing. But Heller, McDonald, and Bruen, in my opinion, are some of the clearest writing that we've ever seen from judges. And in my humble opinion, if you have a high school diploma or high school reading comprehension, you can understand these cases. Now, these three stars in the constellation are written with prose accessible to everybody. So what is the phenomenon at work here that has judges and government lawyers failing to understand what seems so clear and simple to people like you and me? Well, as I started my career litigating Second Amendment cases in the Ninth Circuit. So let me tell you a little story. When I began, there was a 1997 article that came out titled, "The Judge the Supreme Court Loves to Overturn." It was about Judge Stephen Reinhart, who's no longer with us. He passed away a couple of years ago. But he believed and stated openly that the courts can and should be agents of social change. Of course, the problem with Judge Reinhart was he meant change that actually wasn't written in the Constitution, whereas we are working to get change to reestablish what is already in the Constitution. But here was a jurist who seemed to relish his oppositional defiance of the Supreme Court, because when he was asked about his reversal rate, what he said was, they, meaning the Supreme Court, can't catch them all. Well, I suppose that could form the nucleus of a plan for judicial defiance, but at some point it becomes counterproductive. The Supreme Court gets to control its docket, you see, and it doesn't have to decide every case on a circuit split. It can delay action on some cases and wait for just the right case to come along, and then like a butterfly net, gather up all the ones that have cert petitions pending and do what it did in Bruen. It gave us a magisterial opinion on how to apply the Second Amendment law, and then it did what we call GVR, grant, vacate, and remand, a bunch of cases. This had the effect of telling a lot of circuit courts, you're getting it wrong, it's time to get it right. But I don't think that the judicial defiance is just based on partisanship. I think there's something more at work here. And I have to credit a friend of mine who kind of quipped this to me one time when we were sitting around discussing this stuff. He says, all these people have PTSD. I said, what are you talking about? He says, post-Thomas stress disorder. And of course, here I'm referring to Justice Thomas and his crystal clear judicial prose that makes any gamesmanship harder and harder to implement. But the trauma for these judges and government lawyers comes from them losing power. See, no living creature wants to lose power or prestige or influence. Okay, these smart and accomplished people, and make no mistake, the judges and government lawyers we oppose are smart, okay, and they are accomplished, okay, and they're not to be underestimated. But they too want their ideas about fixing problems, okay? They think like Judge Reinhardt that they should be, agents of social change. But then Bruin pounded home the holdings from Heller and McDonald that expressly rejected the application of judge interest balancing inquiries. See, what's at play here when applying intermediate scrutiny tests or having judges decide whether or not a gun is an arm or not is we've got judges basically injecting their own value decisions, and of course they're unelected. Well, the Supreme Court has now thrice emphasized that the enumeration of a right takes it out of the hands of government, even the third branch of government, because a constitutional guarantee to future judges' assessment of its usefulness is no constitutional guarantee at all. Well, when you take that kind of power away from people, it leaves a mark. Let me give you another example of this collective post-Thomas stress disorder. I'm known for basically litigating Second Amendment commercial rights, mostly gun shows. Well, I filed my second gun show case in, I think it was 1999 in Alameda County. Now, I'm not conceited enough to claim that no one was litigating the Second Amendment before I came along. My mentor, as Chuck mentioned, was Don Cates Jr., who's no longer with us. But Don Cates would sit me down and kind of, crack the stubborn brain of mine and say, Don, you can't litigate the Second Amendment head on. You have to do a due process claim or an equal protection claim or use some other amendment to try and protect the Second Amendment, because if we end up with an adverse decision, that closes the door forever. So that actually was the practice of most Second Amendment lawyers back in the late 90s, early 2000s. But then I ran into this judge on this gun show case, and the word Second Amendment did not appear in the complaint. It wasn't argued at all to the court. It was a pure First Amendment commercial speech case. But this judge took the liberty, in his opinion, dismissing our case, obviously, to gratuitously remark that, and the plaintiffs did not even plead a Second Amendment claim, and well, they should not have, because we all know that the Second Amendment is not a fundamental individual right. It's a right of states, it's a collective right, and no individual plaintiffs have the right to raise it. Well, funny thing happened, though. When the judge did that, he introduced the issue into the case, and we didn't. So when we got to the Court of Appeal and actually had a favorable panel, we argued it. And the Ninth Circuit panel found that, indeed, the Second Amendment is an individual right, and it did apply to the states, and then all hell broke loose on the Ninth Circuit. Without either party asking for en banc review, the court on its own motion took the case up on en banc review, and there was a battle back and forth and back and forth. The case ended up being litigated for almost 13 years. And then during that time, Heller came down, and then 2 years later, McDonald came down. So this defiance, this attitude of, well, we can just inject our personal political views into a case where an issue's not raised, kind of backfired. The point of the story is that the trial judge felt confident enough in 1999-2000 to just make a gratuitous swipe at the Second Amendment, and then to say that it was dormant and meaningless, and that the right to keep and bear arms, was stillborn. The plan backfired. Well, what's the point of this? Well, all of this has happened from 1999 to now in about 25 years. Contrast this with the 14th Amendment being ratified in 1868, and then the Privileges or Immunity Clause being gutted in 1872, the Equal Protection Clause being reinterpreted to mean separate but equal in 1896, and then the 14th Amendment lay all but dormant until 1954's Brown versus Board of Education that overturned Plessy. And we're still litigating to this day what the Equal Protection and Due Process Clause of the 14th Amendment means. Is there hope to resuscitate the Privileges or Immunities Clause, as Justice Thomas's magisterial concurring opinion in McDonald talks about? Don't bet against Justice Thomas on this. okay? We're moving farther and faster on resurrecting what was a dormant Second Amendment since the late 1990s than the Equal Protection and Due Process Clause of the 14th Amendment did over almost a century of being gutted by the Supreme Court right after the Civil War. Now, the journey today and forward still requires more work. Here's what you need to understand, folks. There is no final victory. I do a lot of other civil rights litigation, Fourth Amendment, First Amendment. Our rights are never secure in a one and done case. We always have to keep fighting these people because they keep coming back. The first cases I ever filed as a Second Amendment litigator were to protect gun shows. We're still fighting to protect gun shows in California because they keep passing more laws. They think that if the county policy gets struck down, well, maybe the state can try it. And they're basically using, our resources, our tax dollars to do it. But there are cracks in the facade. The Ninth Circuit itself is coming apart. There are judges on the Ninth Circuit that are documenting in dissents from en banc review and dissents from en banc decisions overturning favorable three-judge panels that are saying, look, there are procedural irregularities in what are taking place. Well, what happens when the opposing team wants to change the rules mid-game? That means they're panicking. That means they're frightened. That means they know they're going to lose on substance. Another sign that we're winning is here we are in 2024, just 25 years later after this judge in the Ninth Circuit, the trial judge thought that he could just dismiss the Second Amendment with an offhand comment, where one of the candidates for the President of the United States, a person who was actually Attorney General of this state, is having to put on the charade of pretending to support the right to keep and bear arms and admitting that she owns a handgun for self-defense. Folks, this is constitutional whiplash, and I believe it is part of the source of the defiance we see from judges and government lawyers. I want to say a few other comments on why there's hope here. The fight is now being waged by some heavy-hitting law firms out of Washington, D.C. and some of the big capitals. It's no longer being done by little solo practitioner firms like me or small firms like Chuck Michelle down south, trying to get funding from NRA or Second Amendment Foundation. There are some big heavy hitters coming into this and helping this. And I also want to pause here also and commend some of the young blood and young lawyers that are coming along. I've worked with several of the lawyers in Chuck Michelle's firm. I want to give a shout out to Joshua Dale, Costas Morris, who spoke before me, Alexander Frank, and my co-counsel on several of the Second Amendment commercial rights cases I've been working on recently, Anna Barvier. We won the junior sports marketing case, which is strictly a commercial speech case. We're still working on a gun show case, and we have several other commercial rights cases in the pipeline. So us old guys, as we reach the end of our useful life, just know this, that there is plenty of young blood that is flooding the market, and the Second Amendment is no longer some boutique, obscure area of law that you could theoretically be sanctioned for talking about or discussing in your briefs before. Because, as this judge learned in 1999, it's not a constitutional anachronism. So, where are we? I guess if I have to answer the question posed by the title, are we winning or losing, I'm going to resort to lawyers' weasel words and say both. We're winning because our opponents are in a panic. They're resorting to procedural games to try and win substantive arguments, but we're turning the table on them. To paraphrase Judge Stephen Reinhart, not what he actually meant, but what we mean, if we keep filing cases to hold the line to preserve our right to keep and bear arms, the bad judges won't be able to catch them all, and the honest judges will start ruling in our favor. So keep spreading the message of right to keep and bear arms. Please keep supporting the Second Amendment Foundation, and please keep insisting on exercising all of your rights under the Constitution. And one final thought. Everyone thinks that the first words of the Second Amendment start off Come on with me. A well-regulated militia, right? We all know that. But there is an argument for the proposition that the actual first three words are "we the people." And it's up to us to insist that government obeys that sentiment, that we are the government and they work for us. Thank you.
Thank you, Don.